All right, all right, all right. It looks like we are live. Have y'all heard that the Sarah Boone trial is finally starting? Yes, the lady who has been accused of unaliving her boyfriend in the second degree by leaving him in a suitcase overnight is finally getting to trial. And I mean, after 9 attorneys, not including herself, by the way, she did represent herself for a moment, she's finally making it to trial, and we're finally going to be able to see all the evidence that the state has to introduce against her, and all the evidence that the defense is going to introduce. And what is surprising to me, but also not really surprising, given the fact that she went through 9 attorneys, it's pretty much set that she's going to be testifying, which we don't see a lot on live trials and trials in general. The defense usually does not testify because they do not want to incriminate themselves. But I feel like lately there has been quite a few cases where people are testifying in their defense trials and, again, not doing so well, resulting in them being convicted. And I don't think that Sarah Boone's case is going to be any different. Let me know what y'all think about the case. I hope you're not tired of the case yet, because I know a lot of people have been covering it. It's been on all day. There's been jury selections. There have been pretrial motions, and we are going to get into the pretrial motions. We're also going to get into all the attorneys that Sarah Boone has had and how we have landed on what, in my opinion, is the clout chasing attorney that took her case at the last hour, literally at the last hour, to the point where in these pretrial motions, the attorney is all like, oh, we just came onto the case 45 days ago. And whose fault is that? That's your fault for being a clout chaser, in my opinion. And y'all will see why I'm saying that the attorney is a clout chaser. For those of you who do not know, and kind of, I don't know, Kimmy actually had to tell me, but the jury has been set. So we should be in, if opening statements didn't happen today, sorry, I didn't have time to look up whether opening statements happened today or not yet. We should be hearing something tomorrow, and the case should be underway. I will not be covering the case gavel to gavel because your girl got to go to work. And I actually have quite a few hearings of my own next week. So I will not be covering the case live stream, but I will be trying to give updates on the case. If y'all are watching live, make sure you hit the like button. We are going to set our like goal for the live stream too. Let's see where we are right now. Uh-oh, what happened here? Okay, we have 9 likes with 17 people watching live. So if you have not hit the like button, make sure that you do, because we are going to try to hit a like goal of 65 likes this live stream during the live stream. Of course, if you're watching on the replay, you can still hit the like button, but it will not count towards our like goal. Now, make sure y'all are dropping y'all opinions in the chat section. I'm going to jump into the chat. Then we're going to jump into pretrial motions and how that hearing went. We're not going to watch the whole thing, y'all, because it was like 2 days of pretrial motions. And then we're going to jump into what I think is very interesting: the timeline of Sarah Boone going through 9 attorneys. And if you're really counting all of her attorneys, 10 attorneys, because she did represent herself for quite a while. One thing that I did not do was pull up the letters that Sarah Boone wrote to the court, because I think we're going to have quite a bit of content to get through today. And then maybe we'll follow up with some of the letters and some of the insults that she was throwing at her attorneys. I just haven't had time to fully go through it yet. So I'm gonna have to look into that, and then we'll get into it. Let's see Bossy B, because we miss her and it's been quite a while. All right, all right. Let's see who we have here. We got Layla Wells checking in early, saying hi, hello, and welcome into the live stream. Nice to have you back tonight. We got John Smith, who doesn't like me reading his chat, and I just did, but saying hello, John Smith, welcome in. We got Phoenix Waller saying, hey, yo, all, hello, and welcome back into the live stream. Nice to have you back tonight. Skipping John's chat, we got Crystal Harris saying live in the hive. Yes, we are. And like I said, we have quite a bit to get through with Sarah Boone. Like, this is going to be insane. And y'all, I'm ready to dive into the mess. Let me know if you guys have been into the mess, or if y'all are just coming and catching all the tea right here on the BriHive. Phoenix Waller says, every time I glance at the intro image and see the clout chasing, all I hear in my head is CC Suarez's voice saying, clout goblins, LOL. Yeah, clout chasing attorneys for sure, in my opinion. And y'all, let me know, what do you think about these new attorneys? If you have been keeping up with the pretrial motions, and everything that has happened before we got to this trial week, which I was like, never thought we were going to get here, right? Let me know what y'all think so far about the attorneys. I kind of gave y'all a hint of what I feel about them in the title, on the thumbnail of the live stream, and also in my poll that I did, not like on the stripper poll, but in the poll that I did on YouTube about how the judge is taking these attorneys seriously. I don't want to jump too far ahead quite yet, but y'all kind of got a gist of what my opinion is on these attorneys. We got Mindy saying, dang, I didn't get a notification. Well, I'm happy that you made it in nonetheless. We got Chelsea B saying, hey, everyone, ready for the crazy Sarah Boone trial? I am ready. I don't think they actually not sat the jury. Kimmy already told me they sat the jury. I don't think they started opening statements. Kimmy can confirm that to me. And then we got Kimmy Locker, a member of the channel, moderator of the channel, consultant of the channel, paralegal of the channel, and just made us a beautiful PowerPoint presentation because, y'all, I tried to make a presentation and Kimmy was like, it's too content dense. And I'm just like, yeah, I need to remind myself of what to say. Kimmy, please make it pretty. And Kimmy did make it pretty for us so that it's super easy to follow, but I'm still going to give y'all all the details. So make sure y'all say thank you to Kimmy. And I'm also saying thank you to Kimmy because I was like, I need a timeline, but I don't know how to do it on the internet. Can you tell I've been out of school for a while, right? CW says, my first live. Well, welcome in. We're happy to have you in. We got Destined to Be, also known as Tanya D, who is a member and moderator of the channel, saying checking in and dropping one of the membership sunflower emojis. Hello and welcome in. Nice to have you in tonight. What do you think about the case? I know Tanya D been keeping up with the case. I've seen you in a couple of chats, but I don't remember if it was the Sarah Boone trial or not, but I did see you in somebody's chat the other day. Oh, you know what? It was Young Thug because it was AV's channel. That's where I saw you. Okay, we got Hermes saying, hey, Bree in chat. Hello and welcome in. Nice to have you in tonight. We got Crystal Harris saying, can you explain what clout chasing means here? I hear it, but not sure what it means. So clout chasing, do I even know what the definition is of clout? It's basically you talk about things in order that are kind of famous to get you recognition. So, like if you wanted to be in a music group and you saw Beyonce performing on the stage, you might say, oh, Beyonce is my best friend. Or you might make a video bashing Beyonce so that it goes viral. You're basically chasing a high. Let me see if I'm even saying it right. I'm calling it clout chasing it, but do I even really know the definition of clout chasing? I don't know if there's a definition of fully clout chasing, but clout is like, okay, I got some fame, I got some notoriety, and then people chase the clout. Sarah Boone has a what do you call it? What is it called? I can't even think of what it's called. A high profile case. And so the attorney is like, let me jump on that because y'all see why I'm saying clout chasing. Because if you see how she got this attorney, which I did not know this was literally how she got this attorney, you gonna see, y'all gotta keep watching. You're going to see why I'm calling these people clout chasing, okay? And so I just looked it up. Clout chasing refers to the act of seeking popularity or attention by doing things solely for that purpose. That was a way better definition than I gave. Nice, straight into the point, but basically you're kind of seeking popularity, seeking fame, all the same thing in my opinion. Tiny D saying, hey to Hermes. And then Kimmy Locker saying, opening statements start tomorrow. Okay, sounds good. I gotta go to work. I've been watching this like in the morning on my way to work, and then I get to work and then it takes me like a minute to start work because I don't want to turn it off. So yeah, tomorrow's opening statements. Thank you, Kimmy, for confirming. Kimmy also says, it's still not the prettiest PowerPoint, but it does the trick. It's better than mine. It's better than mine. Crystal Harris says, Kimmy is the best. Yes, of course. Kimmy Locker says, aw, shucks. We got Crystal Harris saying, ooh, I got you. And then we got Destined to Be saying, oh, I think you were talking about the clout chasing, confirming. Destined to Be says, I haven't been following this case. I've been watching the train wreck that is the YSL trial. I want to watch YSL, but it's so far in. We're like dang near a year into that trial, and I haven't watched one full day. I think I watched opening statements, And then I only watched the state's opening statement and then part of Young Thug's attorneys. And then after that, I was like, okay, this is too many. This is too much. They have too many defendants and too much going on. I can't sit and focus on that for that long. But I'm sure it's tea. We got Equality saying, hi, BriHive Chat. Hello and welcome in. Nice to have you back tonight. We got Crystal Harris saying, your definition was fine. Oh, thank you. I was struggling through it. Equality says Owens was super annoying today. Extra. Yeah. That guy, I think he started to give up. That's my opinion. I think he started to give up at one point. So I can't say he was annoying. I did only watch the morning session, so I don't know what happened after lunch, if you guys were able to see that. And then we got Chelsea B saying watching YSL is a full-time job. It is. I feel like you wouldn't be able to think, live, breathe anything else. But there are some attorneys that are covering that case on their channel that is still able to cover other cases. I don't know how they're doing it. I wish I could do it. Okay. I really wish that I could do it. I wish I didn't have a job. No, don't let me not say that, because if I lose my job, that's going to be bad. But if I didn't have a job, I would sit there, I would watch it, I would give recaps, but I don't have the time. I don't have the time. And I honestly feel like I would probably be quite confused because there's so many moving parts, so many characters in that case. Anyways, enough with YSL. We are going to, I got this one thing from Tanya D saying YSL will be taught in law school about not to try a case and be a lawyer. I am not surprised about that. Like I said, too many moving parts. I don't know why they charge all those people at the same time. I get like judicial efficiency, but that's just too much. Who are we accusing today is what my question would be on a daily basis. Equality says, I'm still glad Sarah has Owens. I can't imagine pro se Sarah. That'd be unbearable. But Owens, you knew what you were getting into, y'all. When we go through the list of attorneys and the problems that these attorneys had with Sarah Boone, y'all are going to be like, what? If you haven't read the motion, or the order that the court made finding that she is no longer entitled to be what is the word? Appointed a public defender. If you read that, then you already know the mess. But if you haven't read that, you guys are going to be like, what? Why, Sarah? Why? And I'm not surprised. I'm really not surprised. Destined to Be says, I can watch and turn it off when I work. Yeah, I cannot listen to something and work at the same time, because I'm just going to end up listening. And then I start taking notes, and then, I'm not doing any work, and then I'm fired. And then maybe I can stream every day. Maybe I should start watching YouTube during my work day and then I get fired. I don't want to get fired though. So Kimmy Locker says, there are so many defendants in the YSL case. I don't think it's judicially efficient anymore. I don't think so. I think it's forcing it to be a longer case than it needs to be. And it's like the clout. It's the clout chasing, right? Let's get a good case under our belt and convict these young thugs. Equality says Judge Kranig makes everything better though. I love him. I don't know how he does it. I really don't. And y'all, when I watch these things, I'm not usually watching the actual video. Like, I'm usually listening to it. I had to stop and look at my phone so I could see what the judge's face was. Like, I literally went and rewatched the session because I was like, ain't no way he did not make a face. And he didn't make a face. I don't know how, but he gets to the point where he's like, okay, anything else, counsel? All right, so this is my relationship. I was like, yep, just let them go. Let them go away. We don't have time for this. Get them out of there. Destined to Be says to John Smith, I wasn't even watching until Glanville got kicked off. See, I was going to start at that point. I still can't. I can't. My brain is all in swirls. I'm trying to get this channel better. I cannot go into that. Okay. Equality says we should encourage Bree to listen to so she gets by. So I can be on here all day now. Destined to Be says he is great to Equality. And then we got Darlene said about the judge. Darlene is saying almost a year, probably will be a year by the end of it. It's ridiculous. And they said that was their time estimate, was a year. So are they not on the defense's side? I mean, the defense is presenting their case yet? I don't even know. I'm so far removed from that trial. I wanted to cover it. I just can't. Equality says, right to Tanya D. He's the best. And then Tanya D says he is so chill. He is chill. He is chill. I had to go and watch his little comb over, make his, I guess it's not a comb over, but his little slick back hair, make his rulings. I was like, there's no way. I couldn't be a judge. I just could not be a judge. Equality says, are the jurors okay? I'd go bankrupt. They were saying that about the attorneys too, because the attorneys have to be paid. But these people are in jail. They don't have any money to pay. They're being accused of RICO. So any money that they have is probably going to be forfeited. They can't use it. So some of these attorneys, the defense attorneys, are working for free. Like, could you imagine working for free? Like, the money probably sounded good in the beginning, and then now all of a sudden all the money is gone and you're working for free. You're not seeing your family. You're not eating. You're not sleeping, because there's all this stuff going on every single day of your freaking life for a year for these people you don't know, but you decided to go ahead and represent. Same thing with the jurors. They're not able to go to work. I think like the court pays them a small amount, but if you have a good job, that's not cutting it either, right? And then you're missing time with your family. You're bogged down with the trial. Maybe you got like a negative attitude now. It's too much. Darlene says, yeah, I feel sorry for the jurors. I agree. And then Equality says, that's crazy. Absolutely. I know I said that I was going to go ahead and jump into Sarah Boone, and now I am going to go ahead and jump into Sarah Boone. And Kimmy, were you able to grab the spot for, what was it called? The spot for Sarah Boone's motion today, where the state hands the butts to the defense. Okay. Anyways, y'all, don't forget down below, if you're watching on the replay, that we do have timestamps, but let me go ahead and repeat that for the people on the replay after we bring in Bossy B for jumping into Sarah Boone's pretrial motion. All right, before we start Sarah Boone's pretrial motions, I do want to go ahead and remind the people that are watching on the replay that if you are watching on the replay, there are timestamps down below. So if you want to skip around in the video, you definitely can. If you are here live, you are stuck with me and going in regular time speed, okay? Unless you come in late and then you watch on 2x speed or something. But I feel like I talk fast when I'm on live stream, but then I'll watch the live stream back and I'm talking like really slow. Anyways, into Sarah Boone's pretrial motions. Fortunately, y'all, I don't have a pretty PowerPoint for y'all, and I'm also not going to sit and watch that entire thing because it's too long, and we got more important things to get into, like how Sarah Boone ran all her attorneys out of her representation and how she pissed the judge off to a point where he said, no more attorneys. Like, you're a kid and you're like, no more candy. You can't have any more candy. That happened to Sarah Boone. She's in trouble. Okay. If y'all haven't hit the like button, our like goal for the stream is 65 likes. We are currently at 23 likes. So if you haven't hit the like button, which I know there's some of you that have not, because there's 28 people in here watching live, make sure you hit the like button so that we can hit our like goal for the live stream. Now, into Sarah Boone and what we're calling the pretrial motions. I'm not going to cover everything that was in the pretrial motions, but I'm going to kind of touch on the highlights. One of the big things that have come up with this new representation that Sarah Boone has is that Sarah Boone wants to assert that she was a battered spouse. She did this to Jorge because he was beating on her on a regular basis. Now, what I will say, although Jorge is the victim in this case, and we're not victim blaming here, these people had a tumultuous relationship, okay? There was restraining orders against him for her and restraining orders against her for him. And there was a little bit of combat going on. I'm not going to lie. There was a little bit of combat going on between them. But what happened that day, is Sarah Boone going to be justified in what she did that day? Y'all can let me know what y'all think in the chat. Do you think that she is going to be able to succeed on the battered spouse defense? Because essentially she's admitting that she did this at this point. Remember, at first it was, oh, it was an accident. Oh, I fell asleep and I didn't know. Oh, blah, blah, blah. It wasn't me. It wasn't me. I didn't know that was going to happen. I didn't mean to do that. And then now we're going into a realm of self-defense. If you're saying that it's self-defense, then it's, yes, I did it, but I did it because in her opinion, she's afraid that he's going to get out the suitcase and beat her up, despite him being in the suitcase crying. He wasn't crying, but pleading with her to let him out. She thought once she lets this man out, which I was surprised to hear how small he was, let him out, he was gonna, hand it to her, is what she thought. But he wasn't making any threats in the suitcase. From the videos that we have covered on this channel before, I have a pre-recorded video. If you guys haven't seen that, I'll probably attach it at the end of this live stream, where he's pleading with her to get out. And she's like, yeah, basically that's what you get. You should not have effed with me, essentially, is what she was saying there. Anyways, so pretrial motion, the state says that Sarah Boone should not be able to bring up the battered spouse information prior to her getting on the stand and testifying. The defense's position is that you're basically forcing us to call our client as a witness to testify by making that ruling, saying it was the doctor. They wanted the doctor to testify about things that Sarah had told her that Jorge had done to her, that made her basically fearful of him just kind of on a regular basis, or if she did something wrong, that he was going to retaliate against her. And they want, and I forget what the doctor's name is, they want to bring that expert in to testify to what the battered spouse syndrome is, and whether Sarah Boone is like kind of a candidate or like a common, I guess not a candidate, but y'all get what I'm saying. Basically saying if she would fit that mold as a battered spouse. State is like, that information should not come in until Sarah Boone or someone provides evidence that these kind of incidents has happened before. And other than that, and in addition to that, which I made a note of, or that comes into the second day, so I won't bring it up quite yet. So basically, expert cannot testify until after Sarah Boone testifies, but defense wanted expert to testify before Sarah Boone testifies. So they're kind of mixing everything up. And during this request, the defense, in my opinion, is kind of stumbling all over the place. So we're going to watch a little bit of what the defense attorney is saying and why he's saying that it should come into play. And one of the big things about the battered spouse is that in order to kind of trigger self-defense, there has to be an overt act. If y'all know what the overt act is, go ahead and drop it in the chat section. When this man came out and said the overt act, I was driving my car. Okay. I was on my way to work like a good Samaritan would be. And this man disclosed the overt act and then got mad. Well, he didn't get mad, but he kind of had a little attitude. The state is forcing me to show my cards by telling y'all what the overt act is. Y'all, I think I'm on the right place on the video. So bear with me if I'm not quite there. We are going to jump into it. I'll probably play it on a little bit of a speed here. I need to be able to share the audio. Here we go. We're going to share the screen. And let's check out what this overt act is that Jorge supposedly did in order to trigger Sarah Boone's behavior towards him, leaving him in a suitcase not to get out. I wanted to mark this, and then I want to make this bigger. Okay, so what is the overt act that they're saying? And y'all let me know if y'all can hear it, okay?
Of self-defense has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor.
Okay, and so I'm speeding it up a little bit. Y'all let me know if it's too fast or not, okay?
Doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited, and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be.
This is when I put my poll. He literally just contradicted himself. First, he said that the expert should testify first. And now he's saying it has to start with Sarah Boone. That's exactly what the state is asking for. Like that's what they're asking for. They're asking for, in order for this information to come in, Sarah needs to testify first. So here he just admitted it, right? And he does this throughout his pretrial motions. I don't know how he got hired by the other guy, but this guy is the one that is always contradicting his statements. I haven't really noticed it with the other guy, with Owen. So
made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog, and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Okay, so the state is asking for this information not to come in. No self-defense, no statements about what Sarah had been through without Sarah first testifying, right? They never asked, what is the argument? They're basically saying the evidence that we have do not support an argument for self-defense. So unless they have, if they have some different evidence, then Sarah needs to testify first. That's the state's position. Listen to what this guy, I don't even know what this attorney's name is. He's embarrassing me by association. I don't know where he comes up with, okay, since they're saying the evidence they have doesn't support it, instead of us just agreeing that we won't put the doctors on first before we put Sarah or someone else that can testify to the self-defense nature of things, listen to what he does. Listen to what he does.
Just can I respond?
Briefly.
Briefly, please, briefly, sir, because you're going to confuse us all.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's
Just cut him off.
argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse.
The problem that the judge has to continuously explain why they're there to the defense, not only this attorney, but to Owens as well. He's constantly having to explain, we're not talking about what's in your motion. This is what we're talking about. Do not go off the rails here, buddy. And he's still going to go off the rails.
State's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
And it will be hearsay. You're just testifying to what she told the expert. Best evidence is going to be asked to talk directly to Sarah Boone and what she experienced.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is. That's what this is what this motion has put us into.
Okay,
so it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase.
What?
That means he's about to get out of the suitcase.
No, it doesn't. He never got out of the suitcase. I was like, how did the judge keep a straight face on it? The overt act that made her afraid was that his hand, the two fingers, came out of the suitcase. So he was about to get out of the suitcase. If he was about to get out of the suitcase, why didn't he get out of the suitcase? It's not that he reached his hand out and then she shot him. He reached his hand out, he couldn't get out, and she went to sleep. So how is that an overt act? How? Let's go on.
Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase.
But she didn't. When he put his hand out, she didn't beat him. Or I guess she was beating him at some point. I don't know if this was the point of beating. But even then, she still left him in there overnight. It's not like, oh, he's going to get out, so I ran away. Or, oh, he's going to get out, so I unzipped him and then I ran away. Or, oh, he's going to get out, so I shot him. No, you went to sleep for hours. For hours.
It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat.
Ooh.
That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't.
No, it's not like
And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings, as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions?
Okay. So y'all see how the judge at the end was like, are you done? Okay, sir. Now, this is what I'm rolling. He was so done with him, ready to move on. So for those of you who did not know what the overt act was that Jorge did to put Sarah Boone in reasonable fear, was that he put his hand out of the suitcase. Or he didn't put his hand, he put two fingers. The two fingers were coming out of the suitcase. Now, I've never been inside of a suitcase before, but I can imagine if I could fit into a suitcase. I don't think I can, but maybe I could, because that guy fit into one and he's not much shorter than me. If I could fit into a suitcase and I could put my two fingers out, it doesn't necessarily mean I can move my hand enough to open the rest of the suitcase, right? Because you're probably in there in a ball. You're probably all crammed up and you can't move. So you wouldn't be able to get out of the suitcase. So I think she fails on that. I also think she fails because this is the first time it's coming up. And that's probably why she lost all her other attorneys, which we're going to get into in a minute. Not a minute, probably going to be a little while. But we're going to get into how she lost all her attorneys. And if this is what she was presenting to them, I can see why they got up out of there. Because this is not a good argument. It's not a good defense. In my opinion only. I'm not a criminal attorney. So maybe these people, they've been doing it for much longer than me and they know what they're talking about. However, I have watched these pretrial motions and it does not seem like they know what they're talking about. I feel like he even sounded embarrassed when he said, you know what, the overt act is this. He just kind of threw it out there. He threw it out there. I don't think he even believed it when he said it. I don't think Sarah believes it. I don't think Owens believes it. I don't think the judge believes it. I think the state wanted to laugh because I wanted to laugh. I was like, what the hell? The two fingers that you beat with the baseball bat? Come on now. If he had any chance of getting out, you probably broke the fingers beating them with a baseball bat. Y'all, let's go through the rest of the pretrial motions. I couldn't explain that better than what we just watched. It was a what kind of moment, okay? It was a what are you talking about kind of moment for me. I was confused. So essentially, the court said they're not going to deny the defense outright because, I mean, she's going to testify that that was the overt act that put her in fear, and then she's going to testify to all these other incidences that she's been through before, and then the experts can come and testify and say, well, this is why she's a battered spouse and blah, blah, blah. They can go through the rest of the case that way. I think that it was a good decision by the judge. Y'all let me know what y'all think in the chat. There was also the motion to exclude the officer's opinion regarding Sarah's causing the death in the interviews, and the court actually granted that motion. So essentially, there were some interviews done with Sarah. The defense wanted to blank out some of the opinion statements made by the police officers where they were basically like, well, you know, you're in big trouble. You caused this death. And that is what the court determined that was opinion. And so those parts of the transcripts and that part of the audio should be blanked out so that the jury is not influenced by a police officer who is like seasoned in the job, making a determination that Sarah was guilty. And then there was a motion to reduce the medical records for the hand injuries. There was medical records that was produced over, I think, 500 pages of medical records for Jorge that was produced that Sarah was attempting to use to establish that somehow he is a bad person. And two of the main incidences, which the state actually agreed to, saying, hey, I'm not saying that they can't introduce any of this evidence, but it should be reduced substantially because a lot of it is irrelevant, like the nurse's notes. We don't need to know all of that. And I think it's going to bog down the jury. Very reasonable argument. They're not saying not to include anything at all. They're just saying, let's reduce it to the things that are relevant. The defense then gets up there and say all 500 pages are relevant. The judge had to ask him, how are these, him going and getting blood work and him going to do this and doing that and doing this, how are those things relevant? The defense, as you guys can imagine, could not tell us why those things were relevant. So the court ended up ruling that, let me see. They were going to go ahead and grant the state's motion, but that the court will allow the narrative portion of the specific incidents and the blood alcohol level that Jorge had at the time of the incidences. And so for those of you who do not know what the incidences were, one incident was where Jorge said that he put his hand through a glass. The court basically was like, we are sure that Sarah is going to testify to what were the circumstances around him putting his hand through a glass, which caused cuts and lacerations and everything. Because normal people are not just walking around purposely putting their hand, like punching through a glass, essentially is what I'm assuming it is. And so Sarah will be able to testify. And the court, the state agreed, like, yeah, she can use the narrative to support her argument. Like, he's making the argument for her. She can use the narrative to support her argument. But I don't see why him waiting and him triaging and all of those things are important to the case. And then the blood alcohol level, she's going to say that he was drunk, so he was angry and he broke through a glass and basically injured himself. So the court, the state was okay with that. They're okay with the narrative and then the blood alcohol level for Jorge. The second incident was Jorge got beat up by his family members, I guess, because Sarah's rendition of the facts is that she told his family members that Jorge was beating on her. And so to show Jorge and teach him a lesson that he's not supposed to hit women, his family members beat him up at a family party. The state doesn't think that information is even going to get in as relevant, and it's also going to be hearsay because Sarah is going to be testifying to an out-of-court statement that she made in order to prove that that's the reason why he had the injuries. So I think in the narrative version of the medical records, Jorge said like random people beat him up. Sarah's going to testify to that his family actually was the one that beat him up, but she won't be able to testify, well, I told them this, because she's offering the evidence to prove the truth of the matter asserted. And although she's the one saying it, she can't use her own statements to bolster her position, right? Now, if it was a position of this was a plaintiff and a defendant, and the defendant said, I'm going to beat you up because of this reason, she would be able to use it against them. But since there's no defendant or there's no other person to use statements made against your own interest, those can be used against you. Out of court statements made against your own interest, that can be used against you. But statements made out of court to support your interest, no, you cannot use that. That's considered hearsay. The court does not, or sorry, the state does not think that that part of the testimony will even be able to get in, but they are still agreeable to allow the narrative version and the blood alcohol contents because, of course, not a surprise, he was also drunk on the day that he got beat up either by these random people, which Jorge told the hospital, or his family members, which Sarah Boone is going to assert. So that was the ruling on that pretrial motion. And then we had the motion to exclude the, I already got that one. And then the state objected to the Fifth Amendment evidence list provided by the defense counsel. Apparently the defense never filed. They never filed their amended evidence list. And the court was like, I don't see that. Where is that? I don't see it. And then the state was like, well, you got to ask him because we got it. We've been getting things that are not filed with the court. So you're going to have to ask the defense. But essentially the court did not have time to go over it. So they did not proceed with that day, to my knowledge. There was also a motion for the defense made to exclude all videos and photos that the state is intending to introduce. And then our favorite attorney on the defense side, argued that I'm not objecting to the videos from Sarah's phone. I'm not objecting to this. And then the court was like, well, based on your statement to objecting to all videos and photos the state intends to show, you are objecting to that. You are objecting to it. And then I can't really remember what happened then. I forgot what happened. Let's argue that. Okay. Okay. Yep. So they kind of went back and forth over the photos and videos, and the court basically ended up saying if they're able to lay the foundation, then the videos and the photos and the authentication will come in, because authentication is a pretty low standard, the state argued, and they will be able to bring in the people that extracted the data from her phone and extracted the messages. They will be able to bring those people in to authenticate the validity of those photos and video. So they lost on that. The court basically deferred the state's motion against the evidence list for the defendant until day 2. So we're going to jump into day 2, which started off with everyone being confused. Everyone was confused because the state started off asking the court on day 2, asking the court if they had written the minutes for the hearing the day before. So for the first pretrial motion hearing, the judge did not know. He had to ask the clerk. The clerk basically, they got down to it. They did not have minutes, so they went on recess in order for the clerk of the court to draft up minutes so that everybody knows what motions were ruled on what was that? Tuesday? What motions were ruled on during the pretrial motions for Tuesday. Okay. And then the state recognized that they skipped a part of their motion that we just watched, that no evidence regarding the self-defense or the battered spouse can come in until after Sarah Boone testifies. They also wanted the court to find that no statements regarding previous bad acts by Jorge could be brought up until basically Sarah testifies and brings that into evidence, because you don't want to basically say this person did this bad thing before, so they must have done it now. You actually need someone who has personal knowledge of those incidences happen. And in this case, it's going to be Sarah with the knowledge that these incidences happened, the prior bad act that gave her the mental state that, oh my gosh, if I let him out, he is going to beat me up again, in her opinion. And her defense, right? Let's see the motion regarding the defense exhibit list. They went ahead and went through that, and that was like the longest part of the hearing. So there was the police report and the body cam. Essentially, the defense threw the spaghetti at the wall, and everything stuck. Because it's everything in the kitchen sink. I was going with the spaghetti on the wall, but this one is everything in the kitchen sink. They basically just put everything on the evidence list. Everything, no matter if they reviewed it or not, everything is on the evidence list. And as they went through a lot of the items, the defense was like, "Oh, we're not going to use that. Oh, we're only using that to refresh the recollection of witnesses. So the body cam footage and the police report will be used to refresh the recollection of police officers. They're not going to try to admit it into evidence because it's probably going to be considered to be hearsay." They wanted to enter medical records for Sarah from when she was in jail. And the state was just like, these documents are embarrassing, to say the least. They have nothing to do with her mental state regarding this case. They came much later after the case. They don't have anything to do with it. Again, the defense was badgered by the judge. I don't know if I want to use the word badgered, but that's what came to mind. Was the judge went in on him, okay? Judge went in, how do these records have anything to do with this case? How do these medical records relate to the case? Defense, again, could not tell him. So essentially, they will be able to object to. I can't remember exactly what happened with that one. I think they're gonna let some of them in, but not all of it in, and they have to reduce them down, if I remember correctly. And then the defense brought up the state was objecting to bringing up Sarah Boone's ex-husband. Sarah Boone's ex-husband is supposed to testify because, remember, Sarah Boone's ex-husband is who she called or was he there to pick up the kid or something like that? The ex-husband was there for whatever reason. I can't remember exactly why. They want to bring up that he's biased. So they want to bring up the fact that he has not paid Sarah Boone alimony. The state says, I can understand why he would not want to pay alimony while Sarah Boone is in jail. But what does that have to do with this case. It's not relevant, essentially, is what the state was saying. So they shouldn't be able to bring up these court documents. The case is not even settled. The motion, I think, is like still pending, whether he has to continue to pay her alimony or not, which is insane because we're 5 years in. And if you got 5 years worth of back alimony while this lady has been in jail, I mean, I'm sure if he was paying her, her commissary would be lit. I'm sure that would be the case if he was forced to continue to pay her, but he's filing a motion to not pay her. And so they want to paint him as biased. And to me, that's fine about the bias. You can bring it up and prove that they're biased without actually pulling the documents. What they would need to pull the documents for would be if he says, oh no, I didn't file a motion to take alimony away from her, or I don't resent filing alimony against her. And then that way they can bring up those documents to basically impeach him or show him that show the court that he's biased. But they can also just ask the questions and prove that he's biased. The court ended up deciding that one on a sidebar, so I don't know what the arguments ended up being throughout that topic, but I think the court, let me see, they didn't sustain or overrule. So like I said, if it's brought up in a way to show bias, you ask questions. If he says, no, I didn't file that motion, then they can show the motion and say, this not the motion that you filed, and then we're looking at impeachment. So I don't know. They have weird moves to me, but I mean, I guess if they had to do a full exhibit list, that makes sense. But also, it's like, that's weird. That's weird to put on there. Anyways, like I said earlier, the defense started to indicate that they do not intend to introduce a lot of the evidence that's on their evidence list. They basically was putting everything because, like they said, they came in 45 days ago. That's your problem, not our problem. This is what the judge says. So anyways, a lot of the evidence is kind of just on there to see if they need it, they'll use it essentially. And then the last thing that I noted, I didn't watch the full thing today. There was like 5 minutes left of what I didn't watch today. I think there was 5 minutes left of what I didn't watch today. But the defendant requested, or the defense requested, a statement of particulars from the prosecution. Essentially, they wanted a list, or not a list, but they wanted the state's position. What is the state going to be arguing in order to prove their case? And when this part came up, I was like, are you serious? Are you freaking serious? How do you not know the state's position? It's everywhere. It's in her own story. This lady locked him in a suitcase with a depraved heart and went to sleep. There's not much to it. I was going to show you guys the clip of how the state basically, he just drug the other attorney through the mud. Because he was like, they wanted to know our position. So now we want to know the state's position. If you are coming into this case and you don't know the state's position, you should not have come into this case. Everyone knows what the state's position is. This lady locked this man in the suitcase and she caused the death with no justification. That's the position. But the state, very tactfully, in my opinion, went ahead and read the transcript of her having a depraved heart, in that they basically read out what happened in that video. Jorge in the suitcase saying, help, Sarah, stop, in which I'll attach the video that I pre-recorded regarding it with the videos in it. And Sarah basically saying, whatever. That's how I feel when you do this to me. That's how I feel when you do this to me. And then she like laughs and she giggles and all this stuff. It was very well done, in my opinion. If I can find the clip, then I'll probably cover it on another live stream, but I don't have time, and I don't want y'all to see me trying to find where it was, because I think I stopped at a certain point, but it's not showing up when Kimmy tried to help me find it. So anyways, that's where we are with the pretrial motions. Sarah Boone is going down. She should have took the plea deal. She really should have took the plea deal. I don't know any jury that can be on her side. The good thing for her is that the jury has not been here the entire time. The judge knows her nonsense. The state knows her nonsense. Us people on YouTube know her nonsense. But if they pick the jury well, the jury will not know her nonsense, which I've told this case to people around. And mind you, we're not in Florida, but I've told this and they don't know about the case. So maybe they were able to find jurors that really don't know about this case and the nonsense that she has been pulling over the last 5 years. So my thoughts is she's going to lose. My thoughts is that she's going to jail for a long time. I think her minimum is like 22 years, if I remember correctly. And they were giving her a deal for 15 and she said no. And you know what? She's going, my position. Oh no, I'll get into that when we get into the attorneys, actually. Skip that, scratch that. Don't listen to nothing that I'm saying. Okay, let's go ahead and jump into the chat again. Where's Bossy B? All right, y'all. And we are currently at 36 likes with 32 people watching live. I know there's some people that's just popped in that haven't hit the like button yet. So if you have not hit the like button yet, please do. It does help us out in the algorithm. And yeah, we like likes and new friends. So if you like the button, we might get new friends on the BriHive channel. Let's see what everyone has to say in the chat. Thank you, Kimmy, for starring the relevant chat and see what people have to say. We got Destined to Be saying, thanks for everyone who already hit the like button. Yes, of course. Thank you for the reminder on that. We got Equality saying, no, that video will be in evidence. She's effed. Which video? Which one? Equality says he was begging for his life. Yes, that one is in evidence for sure. Darlene says, but she needs snacks and high heels for the Wait, what were you referring to for that one? Chelsea B says their overt act was one of the more ridiculous things I've heard trial watching. It was horrible. And like I said, I don't even believe he believed it when he said it. Like, I feel like the judge was explaining to them, this is what needs to happen. And he might have low-key sabotaged them because no one asked him what is the overt act? But I mean, I guess to overrule the other one. No, because the court was going to overrule that objection anyways because the state didn't cite the proper case law for it. So he did not need to tell us what his opinion was or what their argument was going to be with the fingers coming out the suitcase. Mind you, if he didn't tell us that, I think everyone would have been confused about what the overt act was in the trial. Like, I feel like they would have tried to slide it in there and we all would have missed it. So I'm glad he came out and said it. I think he low-key did it to sabotage. That's my opinion because it's like, this is the stupidest defense. I'm just going to tell y'all what it is. So y'all don't think it's me. I'm just going to put it out there. It's bad. It's really bad. Equality says to Chelsea B, yeah, it was almost humorous. I mean, seriously, yeah, it is humorous. It is. I was like, y'all almost crashed my car. No, I didn't almost crash my car, but I was just like, what? Chelsea B says to Equality, I respect the lawyers for doing their job, but these arguments are disingenuous. It literally, I think that's why a lot of the attorneys left her, because I think this was her MO the entire time. She was going to try to pull this the entire time. The other attorneys were not listening to her, so she went with these clout chasers, and they did it for her. Equality says to Chelsea B, exactly. I was defending Owens when he came in, but I can't anymore. He's a clout chaser, in my opinion. Why am I singing on YouTube when I can't sing? Chelsea B says equality. I think he thought he could get her to plead, but bit off more than he could chew with this Looney Tune. My thing is, you could not have been watching this trial or the developments in this case. You couldn't have even, and y'all, the documents are public. They're free. You can go look them up. You can go and look them up. He could not have possibly gone and looked up what Sarah has been doing throughout this case. The fact that you have lost multiple attorneys throughout this case, even the one you paid, you lost that attorney as well. That's a problem. Like when people call and try to hire me and they be like, my attorney didn't do what I wanted them to do, or I've been through 2 attorneys, we're not taking your case. You're a difficult client. And then not only are you a difficult client because you've been through 8 attorneys, not including yourself, you didn't even want yourself to represent you at that point, right? Not only that, these attorneys wrote documents explaining why they could not work with her. And you are like, yep, I'm going to sign up for that. Like, did you not read the order ruling that Sarah Boone is incapable and will not be appointed any more public defenders? Any more attorneys? Did you not read that? Because if you read that, you would not have volunteered to do this case. But I think Chelsea B is right. I think maybe he thought that he could get her to plea and then he would be the superhero and it will like bolster his law firm. Now he's screwed. He probably might lose his career over this one. Equality says to Chelsea B, either plea or continuance. I think, nope. The court said no more continuance. He did ask for a continuance and the court said, nope, because we already told her no more continuances. She has been playing this game for 5 years. Equality says, sorry, this analogy was kind of funny, talking about the dog analogy. I thought it was bad. He was like, not to dehumanize him, but to dehumanize him. I didn't like it. I get where he was going with it, but it's like worse than my bowling ball example in a divorce. Okay. Chelsea B says, this was a terrible analogy. I agree. It was, I could see where he was going. It wasn't good though. Kimmy Locker says the dog analogy had potential until he said it was doing arts and crafts, and otherwise just inserted it into the situation at hand. Exactly. It was literally no storytelling at all. No storytelling at all. It was literally what happened during the case, right? Other than the arts and crafts, I think they were playing hide and seek or something. Equality says, I just picture a doggo doing arts and crafts. Sorry, probably not appropriate, but that's what he did. That's the imagery he gave us. Kimmy Locker says to Equality, I mean, analogies are supposed to make visualizing and understanding things easier. So picturing a crafty doggo is the attorney's fault. Yeah. That's what he wanted you to visualize. Okay. Chelsea B says, it made me picture the dogs playing poker picture. Island says, she said she beat his hand with a baseball bat. He wasn't the aggressor. At that point, no. Like, sure, if he beat you up earlier this morning, and you locked him in a suitcase to get away from him, one, I feel like that would be hard to do. I think it would be more justified if he was beating her up and then she stabbed him. That would be more justified. Something that Courtney Clinty is trying to argue. That would be more justified. But this, no. I agree. I think she was the aggressor at this point. And the state did a good job at explaining that. And when I find the timestamp, I'll try to get a video out on it. Darlene said his fingers stuck out. Yeah, his fingers stuck out. It didn't unzip. And then I think at the point that his fingers was sticking out, at some point the fingers went back into the bag and she zipped it all the way closed, if I'm not mistaken, right? I could be wrong. I could be out here lying. Equality says she's hit him with a bat multiple times. Yeah, she is the aggressor at this point. And then like even the statements she was making to him, like, that's what you get. Essentially is what she was saying. That's what you get. Be in there and suffer. And while you're in there suffering, I'm going to go take a nap. Or no, not even a nap. I'm just going to go to sleep and screw you, basically. Island says, yes, she admitted to beating his hand with a baseball bat when he tried to stick his fingers out. So he couldn't even stick them out. And like I said, could be broke. At that point, you beating somebody's hand, his fingers are little. With a baseball bat? Yeah. Alan says, it's like a gun, a finger gun. Yep. Real intimidating. Danette Shipley says, she's saying now that his hand was coming out, so she smacked him with the bat. She's saying she left him in the bag because she was afraid of what he would do when he got out. So yeah, I hope that's not what they were saying, that, oh, he put his fingers out, so she hit him with the bat. I think they were saying the overt act was that he put his hand out, so he was coming out of the bag, is what she said. But even then, even if she hit him with the bat at that point, right? She left him in there for 10 plus hours after that. She could have been like, okay, I'm sorry. You promise when you come out, you won't be mad, right? Please don't be mad. Okay, I'm going to unzip you, but don't get out for 30 seconds. Let me leave the house. She could have done anything. She could have had a friend come and unzip him. But no, she left him in there overnight. And he was already telling her that he couldn't breathe. I was like, she could say, oh, I didn't know that's how it worked and that he wouldn't be able to breathe and that he was unalive. I didn't know that. He told you he could not breathe. Island says, I love that Brie already has Senna in the background. That was literally like always there. I put that there like a couple months ago. So I'm like, my background is like still so plain because I haven't really decided what I want to do with it yet. But I did go ahead and add some more things here. But other than that, like I don't really know what I want to. I really want this to be like a purse wall, but I don't know if it's gonna work with like the setup. I don't know if it's gonna work. Okay, Kimmy Lockett says, so is the argument that his overt act was her committing battery? At this point, her thing is, I beat him, so if I would have let him out, he would have beat me. That was her argument. Equality is, I really don't understand why she didn't take the plea deal. Because he put his fingers out the suitcase, and she thinks that is going to save her. She thinks that's going to save her. Jen Edwards and Leonidas, the kitty, the cool name, saying she is going down hard, too hard. She should have pled. I undermeant what you stood. Love that. The state's attorney needed to phone a friend and ask Runkle for a better analogy. LOL. Yeah, that was bad. That was horrible analogy. Equality says she's so vengeful. She is, and it's almost like a game, in my opinion, to her. It's like a game, and she wants to win the game. That's what I feel like at this point. And these are just my feelings, not facts. Okay, my feelings. Okay, we're at 37 likes, y'all, with 35 people watching live. I know some of y'all have not hit the like button. Make sure you do. Our like goal for the stream is 65. So we would like to reach that goal. So if you haven't hit the like goal, or if you haven't hit the like goal, if you haven't licked the like, if you haven't hit the like button, please. I need to come up with a different saying other than hit the like button, because now I'm asking y'all to lick the like button. It's not going well. It is not going well. Anyways, we are going to jump into the mess that is Sarah Boone with her attorney. So we need Bossy B to bring us in. All right. We are buzzing into some information regarding the attorneys. Like I said at the beginning of the live stream, I think that these attorneys that are on Sarah Boone's case, joining the case 45 days ago, as they like to say, are clout chasers. And I'm going to tell you why I think they're clout chasers. Sarah Boone went through 8 licensed attorneys' offices. Actually, multiple people could have taken the case, right? She went through 8 licensed attorneys, including one that she paid a lot of money because she had him for about 2 years. We'll talk about that. And then she represented herself, and she was bad at it. She thought she would be good at it. She thought she would be better at it than her 8 attorneys that she got rid of, right? Some of them left for other reasons, but for conflicts. So I don't know how they really dealt with her, because some of them left really fast, and we'll talk about it. But these people decided on the eve of trial, if people call my law office and they say, hey, I have a trial next month, the answer is no. The answer is absolutely not. And my trials are not this deep. My trial does not have 500 pages of medical records on a regular basis, okay? We're not doing that. It takes too much time, too much effort. You need too much energy to prepare for trial. And this particular case was going on for 5 years, 4 years. It was over 5 years, right? This case has been going on for 5 years. And you decide that you're going to jump into this case. And I'll tell you why they're clout chasers. Because how they came about and getting into this case, I'll tell y'all after we go through the other 8 attorneys that she went through. So let me get my little life together. I thought I was prepared, and I'm not all the way prepared. So let me get my screen sharing abilities together Which one do I need? Need this one. Share it. And she went through 8 attorneys, and you said, wow, let me be the 9th. Why? I don't know why you said that. So let's start off with attorney number 1, Lydia Labar. I think I'm saying that right. Inception of the case. February 26th. Oh, I kept saying 5 years. I guess it's still a little bit under 5 years. February 26, 2020, the Office of the Public Defender was appointed. That's Lydia Labar was the one handling the case. However, Sarah Boone decided that she was going to hire her own attorney, and she hired, what was his name? Mauricio Padilla. So Mauricio Padilla put in a notice of appearance, letting the court and everyone know that he was going to be representing Sarah Boone in the trial. On March 9th, 2020, the public defender's office went ahead and filed a motion to be relieved, and the court granted the motion because Sarah decided that she wanted an attorney, a private attorney to represent her, which she's entitled to. Of course, she's entitled to be appointed a public defender, but she can also pay for someone, a counsel of her choosing, and that's what she decided to do. Again, shout out to Kimmy for doing the timeline for me because, like I said, mine was ugly. It was not beautiful. It had a lot of words on it, but here we go. So now we are on attorney number 2, Mauricio Padilla. As we just said, he put in his notice of appearance in February of 2020, and he basically became the attorney as of March when they relieved Lydia from the case. Now let me see where we're at. That he worked with her. He worked with her for quite a while. Somehow he survived 2 years and 2 months dealing with Sarah Boone and getting her case ready for a trial. But on April 18th of 2022, he decided that he was going to file a motion to be relieved. And he basically just said, we have irreconcilable differences. We can't really get along. I need to get off the case. The court had a hearing, and Sarah filed a letter objecting to Padilla's withdrawal. So he went through the case 2 years. He said, you know what? I can't do this anymore. Irreconcilable differences. I can't breach my confidentiality to tell y'all the crazy stuff this lady has been doing to me and why I do not want to be on her case anymore. And Sarah goes, well, I don't want you to leave. She says, I want you to stay with me. Okay. And so Padilla, in that, the court was like, well, she doesn't want you to leave. I don't really find any just cause. You're saying that there's irreconcilable differences. She's saying that it's rainbows and sunshine. So you guys should basically stay represented. I haven't had time to read that letter, so I would really love to see what she said in there because she tends to be pretty mean. So I don't know why the court agreed to this. They probably didn't want to deal with her as being unrepresented. But Padilla ended up requesting time to provide the court with more information on the irreconcilable differences, and he provided it pretty quickly. The court and the state was pretty impressed with how fast Padilla really responded, and that, in doing the diligence in order to get the motion filed in a timely fashion. So on May 4th, he did a first amended petition where he indicated that the relationship had become adversarial. So he gave a little bit more information, but he didn't really give us too much information. The relationship has become adversarial with Sarah, which interfered with his ability to represent her and prepare for trial. My guess would be that she wanted to make this battered wife or battered spouse syndrome case. And he was like, no. And it was asked, why do you think, what's the overt act? You need an overt act because Padilla, he's being paid. He's going to be a good attorney, right? I think he would be. So he's probably advising her. This is not a good idea. Sarah's like, it is a good idea. And I want you to argue it. I'm not going to let you off of my case on April 29th. I want you to argue it. So he did a first amendment motion saying that the relationship has become adversarial. They're fighting. They can't agree on a trial strategy. On May 6th, he did a second amended motion and indicated that the relationship deteriorated to a point where he could not effectively represent Sarah as her attorney. So now we're adversarial. First, we're irreconcilable differences. Irreconcilable differences. Why can I not say that word right now? Irreconcilable differences. There we go. Then they're adversarial. And then we get to a relationship deteriorating to a point where he cannot effectively represent Sarah. Okay. And then they had a hearing on May 10th where Padilla cited ethical concerns as the reason for withdrawing. Sarah confirmed that she wanted him to withdraw at this point. So she stopped him for withdrawing for all of a week, all of a week and a half or so, right? And she also said that she indicated that there was a lack of trust between her and Padilla. She did not trust him to represent her interests in the best way possible. So eventually, he was relieved. On May 10th, the court said, fine, Padilla, you can go. Let's appoint her someone else. So we are now through attorney number 2, which did really good. He made it almost halfway through 2022, almost a year and a half with her without leaving her high and dry. Okay. And then we get appointed Eileen Foster. She was appointed on May 10th, the same day that Padilla was relieved. And then she filed a motion to withdraw on June 2nd, 2022. So she represented her all of less than a month. Why did she withdraw? Let me see. She also was with the public defender's office and she filed a motion to withdraw because she represented Jorge in a domestic violence case where Sarah Boone was the victim. So if you guys remember from earlier on in the case, I indicated that these people had cases going back and forth with each other. They was beating each other up. Like, this was a wrestling match type relationship, in my opinion. Okay. This attorney, this public defender, had already represented Jorge in a restraining order case that Sarah was the victim. So Jorge did something to Sarah, which kind of supports Sarah's battered spouse syndrome. So she could not represent him. She would not be able to represent her because of the adverse, hostile, and irascible. Why can't I say that word now? Irascible. Whatever. Y'all know what I'm trying to say. She wouldn't be able to reconcile that she already prosecuted Jorge. She would know things about Jorge that they could basically exploit in trial. Sarah probably would have liked for her to remain the attorney, but it is a conflict of interest. And maybe even Eileen, maybe she didn't think the case was that bad. We don't know. But either way, it is a reason to withdraw from a case. Like I said, she had the case for less than a month. The case was granted on June 7th of 2022. So at this point, she has been through 3 attorneys in 2 years, one of which was there for a year and a half. So he did a pretty good job. So now we are on to David Verrett, who was appointed directly after Eileen was relieved as counsel. And I see some things I want to get to really quick. We got Deacon Fado. Shout out to you. Let me actually come down. And I'll repeat this chat later. Thank you, Deacon Fado. What's my button I want? Okay, there we go. Thank you, Deacon Fado, for the super chat saying my semester class is criminal theory and this case might work with it. I'm sleepy between finding cases for school and such. Well, use this case. It's again, well, do you need something that's already finalized? That this one may not work. But thank you very much for the super chat. I definitely appreciate it. Also see that you gifted 5 Boss Attorney Read memberships. Oh, yes. Definitely appreciate that too. Definitely appreciate it. I'm going to jump back into these attorneys and how we are where Sarah Boone is, which could be a good case for you for school, Deacon Fatal. So thank you again. Okay, we got attorney number 4, David Verrett. He was with the Regional Conflict Counsel's office. He was appointed on June 7th. Y'all see, he filed a motion to withdraw on June 10th, 2022. I'm starting to think that some of these people don't actually have any conflicts, but they do. They're saying that they have conflicts. He indicated that the office previously represented the witness Melissa Sexton in multiple cases. I couldn't find who Melissa Sexton was, so if anybody knows, feel free to drop it in the chat and let us know who she is. I don't know who it is, and I like follow this case on and off. I'm not too deep into it. Okay, and we jump over to lucky attorney number 5, Mark Consolo. He was appointed on June 22nd, 2022. He filed his motion to be relieved in about 2 weeks, 2 to 3 weeks. On July 7th, he filed a motion to withdraw. He cited that he had a conflict, but it was very vague. He didn't say he represented the victim. He didn't say he represented a witness. He just said he had a conflict. What the conflict is, we don't know, but all we know is he got off of that case, and he got off of the case quickly. The court did not ask any more information, at least in writing. And as of July 11th, 2022, he was off of the case. So she's not doing horribly. Some of the people are conflicting out. I think we got 3 people that basically conflicted out. The very first attorney, then we had Eileen, and then we had attorney number 5. Oh, no, 4. There's 4 that conflicted out so far. Okay, so Mark Consolo, he didn't even stand a chance. He didn't even try, okay? Then we got Frank Benkowitz. This is one of her more prominent attorneys in the case as well, along with Padilla, along with the one that I actually have letters of her basically talking crap about him. I'm talking crap about him. So let's go ahead and jump into attorney number 6, which he has 2 slides or 2 pages of notes. So bear with me, y'all, in getting through this. We got Frank Benkowitz. He was appointed on July 11, 2022. He worked with her until December 19, 2022, when he filed his motion to withdraw, citing irreconcilable differences that arose between Sarah Boone and his family. I don't know how that happened, but apparently that's what he said. I don't know if he meant Sarah Boone and her own family, but it said Sarah Boone and his family ran into a conflict. Don't know how that happened, but he wants to be removed. The court set the hearing date for the very next day, December 20th, in which Benkowitz missed the hearing because of a car accident. So the court then reset the hearing for December 22nd, 2022, and Benkowitz appeared, but he could not hear the court. So there was technical difficulties. So the court set the hearing for December 27th, 2022. So he represented her for around 5 months, trying to deal with the arguments that Sarah had. On December 27th, get this, y'all. On December 27th, Sarah did not wish to remove Frank from the case. Frank explained the extensive discovery and the fact that Sarah wants to communicate with him 5 to 10 times per day. Benkowitz was not having it. Sarah wanted to be on the phone with him all day, every day. Is basically calling her a clingy client. A clingy client. She wants to talk to him all day, every day. Let me know what y'all think about it. She wants to talk 5 to 10 times per day, which interferes with his ability to represent his other clients. Sarah indicated that Frank was lying about her need for constant communication. So she's saying that, no, I'm not talking to him 5 to 10 times a day. Maybe you're not talking to him 5 to 10 times a day because he's not answering the phone. Maybe it's because he's not answering the phone, but no. She said that's not true. Frank is a liar, pants on fire. And then she requested during the hearing that she does not want to be represented by Frank. So first she told the court, no, I do want to be represented by him. And then she's like, nah, F you, Frank. I don't want to be represented by you anymore. The court pointed out that Sarah, after she said, I want him to represent me, I don't want him to withdraw, there are no conflicts, I love him as my attorney, right? She then goes, "Oh, F you, Frank. I don't want you to represent me. You be lying." The court pointed out that Sarah had inconsistencies and warned Sarah that she was not entitled to an endless supply of court-appointed lawyers until she finds the one that she personally preferred. He also warned against self-representation, basically indicating that self-representation is hard to do and you don't want to go down that road, Sarah. You've already been through 5 attorneys and you're on your 6th, and this one's trying to bail on you. So get it together or you're going to be on your own. So the court denied the motion to withdraw because at the end of basically that spiel to Sarah, she indicated that she was not requesting to remove Frank for her case. I would be pissed. Worst Christmas present ever. Worst Christmas present ever. Okay. The court directed Frank to have a conference with Sarah before the pretrial conference that was set on January 17th. So second attorney that couldn't get removed upon the initial filing. The first one that couldn't get removed upon the initial filing was Padilla, which represented her for 2 years or a year and a half or so. I don't know. Was that 2 years? No, it was like 2.5 years, actually. I said a year and a half, but it's 2.5 years. He couldn't get off immediately, but eventually did once Sarah consented to removing him. And then Frank couldn't get off because she said, no, I still want Frank to represent me. Poor Frank. Poor Frank hot dogs. We're not talking about hot dogs. We're talking about Frank, y'all. Okay, then we get on. Oh, wait, no, sorry. We're still on Frank. My notes is what I need. Okay, so they go on, right? And then Sarah started writing letters to the court, like 10 letters, if I remember correctly. She's writing and she's talking mess about Frank. And I haven't had time to go through all of them yet, so I don't know exactly what they say, but Frank kind of tells us a little bit about what it says. So remember, he filed to get off the case in December. Court said no. So then on August 22nd, 2023, he filed a motion to withdraw again. So he's now been representing Sarah for about a year and a month at this point, where he's filing his second motion to withdraw, citing irreconcilable difference again. He indicated, and he actually gave us details this time. Remember, some people are being like kind of sketchy. Oh, I had a conflict and irreconcilable difference. I don't want to tell you all the information because it's going to interfere with our attorney-client privilege. So I don't want to give it away. And for those of you that don't know, I'm an attorney. So if we want to get off of a case, we basically tell the court that, irreconcilable differences have arisen to the point where I can no longer represent the client, or the attorney-client relationship has been broken down in a way to where I can no longer effectively represent the client. And usually that's all you have to say, because the attorney-client privilege, the communication that you have with your attorney, is like one of the highest privileges that you can have. People have to be able to openly talk to their attorneys and not be afraid that if you're not doing what your attorney wants, then your attorney is going to go spill all your beans. You have to have that protection so that people are truthfully and openly communicating with their attorney. So most attorneys will just give you vague information, and most courts understand that, and they'll go ahead and drop it. I think in Sarah's situation, she's such a bad client. The court does not want to keep giving her attorneys because they know that this case is going to continue to be dragged out if she is able to run off all of these attorneys. And some of these attorneys have hung in there for a pretty long time. We got Padilla. He was being paid. Maybe she stopped paying him, or maybe she started just being an a-hole, right? Representing her for 2.5 years. Then we have Frank Bankowitz. He lasted a year and a month, right? So he files another motion, and this time he gives us the tea. He is giving us the tea on why he does not want to represent Sarah Boone anymore. He states that the defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. He also indicated that the best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. So he is just upset at this point. Hello. Thanks. He is just super upset at this point. Yeah, that messed up my train of thought. And he's basically like, F Sarah. Sarah, you said F me. F you too, Sarah. Nobody's going to want to represent you because you're a freaking bad client. That's his position. So on September 8th, they had a hearing. And Frank addressed Sarah's derogatory statements where she called him a dud and a buffoon and other mean language. Like I said, she wrote 10 letters about him from like the beginning of 2023 up until this time. And then that she had berating behavior towards him. So she's probably yelling at him, telling him he sucks and all kinds of things. The court expressed concern with Sarah's dissatisfaction with every attorney and cautioned there are certain decisions the attorney gets to make, and stated Sarah has unrealistic expectations and informed her that she is entitled to a private attorney. So basically what the court is saying is you're on your last leg. This is the last straw, right? We're not going to keep giving you attorneys. You have unrealistic expectations about what your attorney should be doing. You cannot be calling your attorneys 5 to 10 times a day. They are allowed to have other clients. They are allowed to work on other cases. You are not number one. You don't have an endless supply. And basically, you should probably hire a private attorney because the public defenders are not able to represent you in the way that you want to be represented. And you need to pick someone that is a good fit for you. It's essentially what the court was trying to tell her. So the court grants the motion on September 8th. Frank Binkowitz, what's his name? Binkowitz. He is free. He is free from the claws of Sarah Boone. And we move on to our 7th attorney named Winston Hobson. Winston Hobson. He was appointed on September 8th, as soon as Binkowitz was removed, on February 1st of 2024. So he lasted with her for about 5 months. He filed a motion to withdraw, citing irreconcilable differences, including but not limited to ethical considerations. Basically, she was probably trying to argue that battered wife syndrome, and he was like, that's not going to fly. It's not going to work, okay? On February 9th, the hearing was held. Winston cited issues including disagreements on legal strategy because she was probably trying to assert that BS that she's asserting now with Owens. Owens is blowing up his career. He's going to blow up his career. Not in a good way that he wanted to. Not in the good way that he wanted to. Let me see where to go. Oh, including disagreements on legal strategy, on what can and cannot be done. She's probably asking him to do some crazy stuff. I can't imagine what Sarah Boone is asking this man to do. A lack of resources and defendant's demands make her difficult to work with, including defendant taking in non-viable legal positions and being unreasonable. So again, he's telling her, hey, you need these elements, you need these things in order to succeed on what you're arguing. And she's like, nah, we're going to do it anyway. We're going to do it anyways. You figure out how to make me win, bro. You're the problem, not me. I'm not the problem. I am not the problem. You are. Figure it out, is what she's telling him. So he's trying to say, hey, no. And the court has already warned her. The attorney gets to make certain decisions. The attorney gets to make certain strategic decisions. If you tell me something and I say, okay, well, this theory could apply and this theory can apply, we're going to argue both theories and the alternative. You do not get to go, it was self-defense. And he goes, ma'am, he was in a suitcase. This is not self-defense. It's self-defense. I don't want you to be my attorney unless you argue self-defense. It's not self-defense, Sarah. It's not. It's not self-defense. Okay? But no. He says she didn't want to listen to him. And she had unreasonable positions. And maybe she called him 5 to 10 times a day like Binkowitz. But he lasted. He lasted 5 to 6 months with her. The court outlined the overriding claims for okay. Where was it? Okay. The court went ahead and basically pointed out the overriding claims to withdraw by Padilla, Binkowitz, and Hobson's adversarial relationship, lack of satisfaction, and inability to meet defendants' desires. And basically saying, hey, look, you've been through several attorneys that you've been causing issues with when he was making his ruling. The court found that Sarah is unable to work with the court-appointed counsel. It explained that the right to court-appointed counsel is not unlimited. Basically, they wrote an order saying all of this stuff. So she had issues with both Padilla, Benkowitz, and Hobson, which is her current attorney. The adversarial relationship, lack of satisfaction, and inability to meet the defendant's desires because she wants to call them multiple times a day and she wants to argue these unreasonable positions according to the attorneys. The court found that Sarah is unable to work with court-appointed counsel, explained that the right to court-appointed counsel is not unlimited. The court has twice advised defendant that defendant may not be provided another court-appointed attorney and that defendant would have to represent herself in circumstances similar to Hobson's motion. Sorry, I'm trying to read my notes and they don't really make any sense. Essentially, the court told her that if another attorney withdraws for a similar reason as Hobson, she's going to have to represent herself. Figure it out. You got rid of attorneys that have worked hard for you. Padilla worked for a long time for her. Benkowitz worked for a long time for her. Hobson worked for a long time for her. And she's still being unreasonable. So essentially the court told her, like, basically, if you keep this up, you're done. You're done. You're going to have to figure out how to represent yourself if someone withdraws for the same reasons. You being an issue, essentially. If you're an issue one more time, you're going to have to represent yourself. The court, again, warned against self-representation, telling her basically it's not a good idea to represent you in this because you don't have the legal experience and the knowledge to represent yourself through this. And the court granted the motion and appointed another attorney. So February 9th, 2024, Hobson is let off of the case. So we are now on to attorney number 8. The last attorney before Sarah Boone started representing herself. Sorry if I gave it away if y'all didn't know, but she went through 8 attorneys before she had to represent herself. So on February 9th, 2024, this is when Patricia Cashman was appointed. On June 7th, 2024, there was a hearing. Let me see what I said. The court appointed Patricia, let's go backward. The court appointed Patricia due to her extensive experience representing murder defendants and willingness and ability to deal with difficult clients. So the court basically thought this would be a good fit. There's no way Sarah Boone is going to be able to run Patricia Cashman off. The court does not know Sarah Boone. The court has been dealing with Sarah Boone for 4 years, and the court still does not know Sarah Boone, okay? February of 2024. She's appointed. June 7th of 2024, Sarah told the court that she has to walk out on several meetings with Cashman because basically Cashman was doing like mock trials with a fake judge. And Sarah Boone didn't like how things were going. So she would walk out on these meetings with Cashman. And then Sarah would attack Cashman's professionalism and filed more letters with the court, basically saying Patricia sucks. She's not representing my interests. I don't like her. She sucks. I imagine that's what the letter says. Cashman advised the court during this June 7th hearing that they have a disagreement regarding the legal strategy. I can almost guarantee you she was arguing this battered spouse position, and Patricia was like, that is not going to fly because this hearing is on June 7th, 2024. 4 months ago. 4 months ago, and you're still trying to get your legal strategy together? Come on. What are you doing here? When Cashman told the court that they're not agreeing on the legal strategy, which is up to Cashman to determine because she is the attorney, if the facts fit the strategy, you go with that strategy. Sarah basically said, Cashman lies. She's full of lies and half-truths. She's not telling the truth. So on June 11th, Cashman, of course, filed a motion to withdraw, not unlike everyone else, citing irreconcilable differences and that her representation of Sarah will interfere with her ability to represent other clients. So we have her demanding too much of the attorney's time and Sarah being difficult to work with. I mean, she's calling her a liar. She's saying she sucks. She's walking out on meetings. You're 4 months away from trial. Why would Patricia stress herself out trying to get your trial together and you're acting like a fool. Okay? The hearing was held on June 24th and the court granted the motion to withdraw. So, what now? Sarah Boone has been through 8 attorneys. She's gone through 8 attorneys. And she still has trial in October. So what does the court do? The court has already warned her multiple times, if you keep this up, you're not getting any more candy. No more candy for you. No more attorneys for you. You don't get to break all the toys and go, see, Your Honor, the system is broken. You don't get to do that. But she wants to do it. That's not going to stop her from trying. So what happens next? The court basically says, you know what, Sarah, you're done. The court writes an order indicating that Sarah is forfeiting her right to court appointing counsel. She can still go hire an attorney, but she will not be supplied any more attorneys picked out, handpicked by the judge. The judge thinks these people can handle her, and they can't. They cannot handle her. I forgot to say, Patricia Cashman was representing Sarah for about 4 months, and she ran her off. Okay. And Cashman seemed like she wasn't giving up. Sarah is the one that brought up issues with Cashman. And then 3 days later, that's when she filed the motion. She's like, bro, F you. F you, Sarah. So what did the court find in the forfeiture of the court-appointed counsel? The court indicated that Sarah never objected to any of the appointed counsel. If she didn't want to work with them, she could have said, hey, Your Honor, I don't like them. I don't like the way they do their thing. 7 counsel were appointed to her, and she hired one. Remember, she paid Padilla. So the court appointed 7 different attorneys to her, and she hired one. And then 4 out of the 8 attorneys that she had withdrew due to Sarah's behavior, being aggressive, being adversarial, being demanding. They withdrew. That was Padilla, Bankowitz, Hobson, and Cashman. The people that worked with her the longest, everyone else withdrew for conflicts. Remember that. Although Sarah did not waive her right to counsel, the court found that she forfeited her right to counsel due to her behavior and inability to work with any attorney. Now, the court cited different case law as to giving them authority to basically remove her, to basically relieve the court of appointing her any more attorneys. They warned against self-representation. They told her, hey, you're walking a thin line. There is a possibility that we will not keep appointing attorneys to you. She knew. The court basically gave her the warning and said that the hearing to determine whether she knew this was coming is not necessary, because they documented all the times that she was told that she's going to lose her representation. And they also, this is the really important part, they also stated, the court stated, the trial cannot be continued except for extraordinary good cause, which we actually witnessed. There was a hurricane, so the trial got delayed a week, not to include retention of a new attorney by Sarah. So Sarah, you can hire a new attorney, but you're going to have to find someone who's willing to represent you in 4 months. So at this point, it's 4 months, right? We're in June of 2024. So she has 4 months to find an attorney to represent her. The court went ahead and relieved Patricia and ordered Patricia to basically put in a request for fees for what she incurred, representing Sarah Boone. So now Sarah has lost her right to court-appointed counsel, and she can't continue the trial anymore. The court said she claims that she wants to go to trial, but she's finding every way to get out of going to trial. Okay? So now, no more continuances. That's done. That's done. You're going forward. And Sarah did. She tried to represent herself by herself a couple of times, but she didn't know what she was doing. What the judge told her, your training, your legal knowledge is not there. It takes a lot to be a lawyer. I know we make it look fun and easy on YouTube, but it's not YouTube, right? My job is completely different than us coming over here and giggling and laughing and talking about cases. We're looking from the outside. We're not doing all of the hard work. We're not going through all of the discovery. And you don't know the laws to even assert the defense that you want. So what does Sarah do? She decides that she's going to get another attorney a couple months later. Okay, so she forfeited her right to counsel on June 28th, 2024, 4 months ago. Like 3.5 months ago, actually. And then we get James Owens to the rescue. And how does James Owen come about? Sarah Boone posts a flyer, a handwritten flyer, and James Owen said, "Oh, wow, I would love to represent her." And what does the flyer say? And hopefully I can read it. It's a little blurry because I'm zooming in. Inmate seeks attorney. This is her flyer. She is putting out an advertisement. And I must say, her advertisement skills are superb. Like, she must have been in marketing before she went to jail, because this is superb. This is the only compliment that I'm giving to Sarah Boone. It's the only compliment. It is a superb advertisement. I need her to advertise my YouTube channel. Okay. I need that. So, inmate seeks attorney, looking for a prosperous challenge, ? Ready for your close-up on national television. This is why I call them a clout chaser. She is advertising this case as the ultimate case of your career. Do you want to be on national television? Represent me, Sarah Boone. Like, I feel like I'm in a car commercial. Okay. So, are you ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. This literally sounds like a commercial. Like, I can see why he bought into it, but also after I would have looked at the case, I would have been like, hell no. No, I wouldn't want to be on national TV and embarrassing myself in the trial. She didn't put when the trial was, so good for her for keeping that out of it. But he could have looked it up. I'm looking up her case, and I'm not even in the state. So he could have definitely looked up her case. She said qualifications must include, this is literally a job post. Literally a job post. Qualifications must include being trustworthy, honest. Let me see. I can't read it. Trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills. Exceptional problem, because she's the problem. Exceptional problem-solving skills. Client, I don't know what that says. Client something at all times. Collaboration. I can't read everything, y'all. Collaboration, extreme efficiency in listening. Extreme efficiency in listening, communicating, understanding, dedication to success, possessing winning mindset, possessing a winning mindset. Okay. Capability of excellence in representation, committed. I think it says committed. Maintaining faith in the client, in case with the ability to think differently, overcome all circumstances. Beautiful advertisement, beautiful job posting. I love it. Epic opportunity awaits. She is advertising this as a once in a lifetime moment. Like this, she the Little Mermaid, and they giving her legs for the first time. This is superb marketing. I don't care what anybody says. She goes ahead and puts her name, her inmate number, and where she is currently being held. Invest in the oppressed, believe. And that is the end of her advertisement. And my boy James Owen said, you know what? This is the time for me to shine. I'm going to prepare for trial in 45 days, like he said. He filed a notice of appearance on August 30th, 2024. So September passed, and then we've been through 17 days of October. And now we're going to trial tomorrow. This guy said he saw the ad and he did not want someone to basically be taken advantage of by the court system and be unrepresented. He knows how scary that can feel, he said. And so he decided he was going to take the case. And with this type of advertisement, this colorful advertisement, I must say, colorful language in this advertisement, the second thing it says, are you ready for your close-up on national television? Show the world who you are with your original creativity. Yeah, because you got to be creative to come up with that. to come up with that overt act, for sure. Creative. Extraordinary expertise. I don't know about that. He hasn't shown it, and it could be because he's overwhelmed with all of the information in the case, because you shouldn't have taken it. I give you that. You should not have taken the case. And the confident ingenuity. This guy said, yep, sign me up to ruin my career. But if he does well, it could bolster his career. It can help him. It can help him. But this is why I say they're clout chasers. He responded to an ad telling him he was going to be on TV. He's going to be the next big star. What was the attorney from Johnny Depp that became the next big star? Forgot her name. That's Camille or something like that. You're the next big star. I don't know why I'm saying star like that. But this is what got him. Clout chasing. Confusion throughout the hearings so far that I've seen. Complaining that you've only been on the case for 45 days. You signed up for it. Why did you sign up for that? Any lawyer would have told you don't take the case. Even if it wasn't this outrageous national high profile case, even if it wasn't that, any attorney would tell you not to take a case 45 days before a trial where no continuances can be granted. And he asked for a continuance. And the court said no. The court said no. There are no continuances here. We already warned her for the last 5 years that she is skating on thin ice, okay? Skating on thin ice, this lady is. And here you come asking for a continuance. The documents are free online. Why did you not read the forfeiture letter? That came out 2 months ago. It would have been easy to find. I found it. What's going on, dude? So that's why I say he's a clout chaser. He's a clout chaser. Let me know what y'all think. We've gone through the attorneys. The jury has been sat. Opening statements tomorrow. I feel like I'm rapping like Glorilla. That was weird. Okay. So we're going to trial. Sarah Boone is going to trial. She should have taken a plea deal, but she didn't. And Owens and friend, I don't know what the other guy's name is. You're going down, and not in a good way. I don't know if going down in a good way is ever a good way, but you're not going to make it. This is not going to do for your career what you think it's going to do. You're kind of like Greengrass in the Laura Owens case. He thought he was doing good. A lot of people come to his blog. Yeah, we go to your blog to judge you, not to support you, dude. Greengrass. Let me know what y'all think in the chat. Have Bossy B bring us in. All right, y'all. What y'all gotta say? Where are we at with the like goal? We are at 53 likes, y'all. What was the like goal? 65. So if you haven't hit the like goal, or if you haven't hit the like button, please do. It does help us out in the algorithm. And we would like to reach our like goal for the live stream. We got Darlene saying, I agree. She says whatever she thinks will help her case. Yeah, I don't know. It's not working. It's not working. She needs to sit down somewhere. She should have took the plea. Equality says, oh, come on, Bree. The poster was beautiful. That's why. It was wonderful. It was very well crafted. It was amazing. Perfect advertising. I wouldn't have fell for it. She was like a used car salesman. As soon as you drive off the lot, the wheels fell off. You couldn't pass smog. This case cannot pass smog. Oh, my analogy was a little bit better than the states earlier. Chelsea B says, sometimes I think she knows she's going to jail, so she's having fun with her final show. Exactly. She wants to be on TV. It's a game to her. I think it's a game to her. Darlene says, don't need to know about Jorge's, that's like George. Don't need to know about Jorge's bandage changes and urine output. Don't need to know about Sarah doctor visit in prison. Exactly. And the state was like, the records are kind of embarrassing for Sarah. I don't know why we would want to put this out. It's just going to confuse the jury. She's going through middle-aged women problems. That's what the state said. Darlene says, loved it when she was called middle-aged. Yeah, he did call her middle-aged. She's going through normal middle-aged women stuff. I don't think it's relevant. I just can't see how it's relevant. Danette Shipley says, supposedly there was injury to his hand that supports his hand coming out and her hitting him with the back. Doesn't excuse her for going up to bed. She's definitely drunk. The thing about it is, even if he did put his hand out, even in that suitcase, if he did put his hand out, I don't even think that justified her hitting him with the bat. They were playing a game. She put him in the suitcase. They're laughing. And all of a sudden he puts his hand out and she started whacking him with a bat. Like, what kind of sick joke is this? I could see if they were fighting and she locked him in a closet, like he was chasing after her and she locked him in a room. But playing a game and putting somebody in a suitcase and then you putting your hand out, that still to me doesn't give you the right to hit him with the bat. Maybe if he like busts the door down, right, and he came out flailing with swinging his hands, maybe that might justify the bat thing. But also this guy was small. So I don't even know if the bat is leaning more towards deadly force to me. I don't know. I don't like it. I don't like it one bit. Okay. Dean Vado, again, thank you for the super chat. Saying the semester's class is a criminal theory and this case might work with it. I'm sleepy between finding cases for school and such. Yes, we already talked about that. And then again, thank you for the 5 Boss Attorney Breed memberships. We definitely appreciate you. Kelly H says, just jumping in and hit the like. Thank you very much. We appreciate that. I undermeant what you stood. Says, I think Mark Consalo was the one who was assigned, but he was already in the process of moving somewhere else. Something like that. Okay, that's why it was kind of vague there. I understand. I undermeant what you stood. Says, or had already taken a new job. I can't remember, but it is in the court records. Yeah, I didn't have time to go through everything. I just kind of pulled the request and some of the orders. Kelly H says, I'm catching up on 1.5 times. I know we think Sarah Boone's lawyers are clout chasers, but I honestly think they are so salty she didn't take the plea deal. That has to be what the goal was here. They thought they were going to come in and be the superhero to get Sarah Boone to sit down. Have you not been listening to the case? I haven't even been following it from the very beginning. But have you not been listening to the case? You are not going to get that girl to sit down. I think it is a game to her. Chelsea B says, I can't even imagine having her as a client. She's vexing just to listen to emotions and letters. Yeah, the letters are crazy. And I haven't even been able to read through them all the way. But yeah, if she would have had to do the trial on her own, it would have been horrible. I've done trials where people are not represented. It's not fun. It's not fun. It's fun for the attorneys because you can object to stuff really easily, but it's just not fun. And the fact that she's going to get up there and do her little show and get on the stand, that girl knows she's going to jail. She knows that she's going to go to jail. Like, why? Why are we putting her on the stand? Brissy Girl says, hi, Bree. From what I've seen of Owen so far and his co-counsel, they seem to never be prepared to argue their motions and never quote case law to back up their arguments. Nope. It's like they just put it in the writing and then they forget that it's even there. And then they just try to focus on that point. The judge has had to tell them on multiple occasions, that's not what we're here. That's not at issue. That's not at issue. If I hear the judge say that's not at issue one more time, I'm going to go crazy. And then like I'm sorry, I don't know his name. The black attorney, he was like, I just have a question about opening statement. Can I talk about it in opening statement? He already said you can talk about it in opening statement like 12 times. He said jury selection and opening statement is free game. If you fail, and the state even said that if they fail to address what they overpromised, right? If they fail to address what they said they were going to address, then we'll deal with it then. State made that argument for you. They're not objecting to you using it in opening statement. They're objecting to you bringing it up without laying foundation, and you haven't laid any foundation. Now they know that you're going to say him sticking his fingers out meant that he was going to beat her up, or maybe it meant that he was going to try to get out of the suitcase. Like, that's a leap. But yeah, sorry to get all spicy on your comment. I admit what you said. Patricia Cashman was, in my opinion, Sarah's best chance at less time. Yeah. And she would have probably tried to get her to plea. And that's probably why Sarah was mad. But Sarah refused to listen to her. I mean, she flat out said, tell her to be nice to me. Because Patricia was probably trying to get her to plea. Everyone probably tried to get her to plea. Okay, as more evidence kept coming out, they're probably like, dude, you are not going to survive this. And then we got this goofy Owens coming in like, you're going to win. No, you're not. You're not. Sorry. Chelsea B, member of the channel. Yeah, I think that's when Deacon Fatal says, imagine being such a terrible person that the public defender appointed to work with difficult murderers can't deal with you. Exactly. Exactly. You just got the boot. You just got the boot that quick. Darlene says, imagine being a high conflict attorney and you can't get along. Yeah. She can't make it work with anyone. The guy who was at Banquet said she's not going to be satisfied with anyone. He called it. He called it for sure. Sarah Boone's 13th lawyer. Please don't. She's not gonna. I mean, she's gonna do some appeals, so maybe you have a chance. Goon for Boone and snacks for Sarah. Good campaign slogans. BJ but no bear. A rational person who thinks the hand coming out means he may break out and harm her would not go upstairs to bed. She would flee the premises while he was restrained. Yep, exactly. And send somebody else maybe to go unlock him or something. I don't know. But yeah, you don't just go to sleep. If you're scared, you don't go to sleep. I'm sorry, you just don't. You don't. Cheryl C says, mild spoiler. Oh, we find out more about Jorge's other injuries late in today's hearing. I didn't see that they had anything after this morning. Was there something else that aired after this morning? I must have missed it. Destined to Be says, not gonna lie, I don't understand how he fit in the suitcase. Not being funny, but was he 4'2"? I think they said he was like 5'1", but that's not much shorter than me, and I don't think I could fit in a suitcase. But also, I think they said he was like 110 pounds or something like that, and I'm more than that. So maybe I'm too big. I'm too big in width, not height. Maybe, I don't know. But you would have to be curled up into it. So I get where you're coming from. It's definitely going to be a tight squeeze for an adult. Cheryl C says, I absolutely hate the reports from people in court today saying that Sarah Boone will testify by narrative. Hate it. I don't want that woman to have open access to a mic. She's just going to go on and on. I don't know if she would testify by narrative being represented by an attorney. Well, I guess it depends on what. Yeah, I'm potentially, because she did change her story. So potentially she will testify by narrative. Ooh. Yeah. Because like when you're when you basically contradict yourself, the court can just make you testify to what your new story is without any attorneys being able to ask you any questions. I don't know the rule behind that. I literally recently just learned that. Destined to Be says, Cheryl C, that will be a nightmare, and it's possible. Sarah Boone's 13th lawyer says, no fight for freedom and Dr. Pepper. Cheryl C says, to Destined to Be, anytime I see someone testifying via narrative, I immediately think everything they are saying is a lie. I think everything she's saying is a lie in general. Just for even having the audacity to say that him putting his fingers out of the suitcase made her scared to the point that she went to sleep. That's sketch to me. And I think even then she could have called the police and said, hey, I was playing with my boyfriend. I locked him in the suitcase. If I let him out, I'm afraid of what he would do. But if they had pending restraining orders, they probably wasn't supposed to be around each other anyways. I don't know if they had pending restraining orders, but I'm assuming the police has been called to their residence multiple times. Stargazer Kawaii says, sounds like she's Sound like she's won't be able to backtrack to it was an accident. Yeah. So initially it was an accident. I didn't know he would die by leaving him in the suitcase. I accidentally fell asleep. Now she's saying, okay, I did it because he's mean to me. I'm glad Patricia Cashman got out of there quickly because there's no telling what she would have did to her. She's now admitted she intentionally prevented him from getting out. Yep. Because she was scared. But if you're scared, you call for help, right? Kimmy Lucker says, don't forget to like and subscribe, BriHive. Yes, of course. I never say that kind of stuff, so thank you for the reminder on that. Cheryl C says, we didn't see anything about narrative on the court feed, but several people who are live in court reported it. I think it's possible. Because she's changing her story. Like I said, I don't know the rule behind it because I literally just learned that. I don't do criminal. So we don't do that in family court. So I don't know what the basis is for that. But I did recently learn that if you change your story, you can testify in narrative. And then they can ask you like follow-up questions, but you get to start off kind of telling your own thing. Justin to be says, I'm actually watching a case of a guy defending himself, and so far he's winning his case. Only one thing isn't adding up, but the court is on hold for a couple. Oh, that's the one I was watching, Tanya D. The one where they're saying he killed a lady because he's saying he got jumped. They're saying he basically, I don't know what they're saying he did, but I watched his testimony. That was the narrative form one. Janine says, if words are coming out, it's like a lie. I'd have to check if she said the sky is blue. Be like, oh, it might be gray today. Might be pink. And then they're asking which case to Tiny D. It is Ohio versus Quentin Nixon. Kimmy. No, Kimmy is not a part of the case, but it's Ohio versus Quentin Nixon. Kimmy says, cool. Thanks. I know. I want to look into it more. I just like literally saw it on TikTok. So it was interesting. I don't know if I did my bookmark for this one. Brissy Girl says, in one of Lawyer You Know's streams about this case, apparently Sarah would smack his fingers with a baseball bat. So if he tried to poke his fingers out of the suitcase, basically preventing him from wanting to do it because she's hitting him with the bat. And she did say that she hit his fingers with a bat. And like I said, if you're hitting fingers with a bat, you could break them. I'm not saying that his fingers were broke, but you could break them. And that would hurt. No matter if they're like doing it hard or not, that would hurt. So technically she's like kind of forcing him to stay in the suitcase. So yeah, I did read that too. Carly Rader says narrative is when the attorney says, I'm not willing to do that, right? There was a case where basically they would be able to just talk freely without them asking the questions. Okay, Stargazer. Oh, that was the next one. Sorry. Carly Rader says, a case where a man had a lawyer but disagreed and the lawyer stood by while he had a narrative testimony. That's possible too. I'll have to look into it more because I really don't know. I'm not going to lie to y'all. I don't know because I don't do criminal law and we don't do that in family law. So the only time you're doing narrative is if the person is not represented in family law. So I would have to look into that a little bit more. A Stargazer Kawaii says, honestly, I think she'd have, sorry, y'all know I can't read. Stargazer says, honestly, I think she'd have done better with, I was drunk and it was an accident for a defense. It might get her less time, but it wouldn't get her off because it was voluntary intoxication. You can't use voluntary intoxication for a defense for unaliving someone, but it could potentially have reduced her charges to like manslaughter or even just less time. But she also beat him with a baseball bat. She also beat him with a baseball bat while he was in the suitcase. So I don't know how much it would have reduced her time. Cheryl C says to Brissy Girl, she also admitted that she hit his head and face with the bat through the suitcase, I assume, which is crazy because you knew exactly where those areas were and then you did that to him, right? So that's really all I have for today, y'all. Uh-oh, what's happening? My YouTube studio doing weird stuff. Okay, there we go. Sorry, y'all. I'm having technical difficulties in the back per usual. But what was I saying? That is all I had for tonight, y'all. So we went through Sarah Boone's pretrial motions, and then we covered all the attorneys that she has been through thus far. So we're done with that. Opening statements are starting tomorrow because the jury has been set. I probably will not be I definitely will not be streaming it live, and I probably won't watch it live. I like watching stuff on like 2x speed because they be taking too long to talk. Honestly, I cannot. I appreciate y'all for being here during my live streams, but I cannot. Maybe mine. I talk pretty fast, and I've sat through some of the colleagues' live streams, but on a regular basis, I just couldn't. So I definitely appreciate all of y'all for sitting through with me as I struggle through with words and stutter and say words wrong. Definitely appreciate it. I am going to be keeping up with Sarah Boone's case. I also have a deep dive that I'm preparing for. I never do updates in the beginning of the stream. I'm going to have to start labeling this. I have a deep dive prepared to go through Courtney Clinty's case and where that case is right now. They locked us out of all the documents, so I'm doing my best to gather the information from reliable sources so that we can do a deep dive on Courtney Clinty's case. And there was another case that I wanted to do, but I haven't started. I need to do Sarah Boone's. I don't know if it's necessary at this point since we're already in trial, but it might still be a good deep dive to go into. Like I said on the last stream, I am going to be bringing some different styles of content to the channel that I'm going to definitely need y'all's feedback on. So be prepared for that stuff to start coming out next week. I know I was supposed to do Courtney Clinty this week, but then Sarah Boone popped up and I didn't finish my Courtney Clinty PowerPoint until Tuesday, so I couldn't record it in time. So, and I was just notified that we hit the like goal for the live stream. We're at 60 likes. It was 65, but we're going to play it anyways because we got close enough. Shout out to the BriHive. If you are sensitive to loud sounds, this is your warning to turn down your volume because we do have a loud boom in front of our like goal. So I'm going to play it in 3, 2, 1. Yeah, you know, the like goal was 65, but whatever. We win. We win. We win regardless of it. I was reaching for the stars. We're close though. Mine is showing 61. Tiny D says hers is showing 62. So still good. Still good. Let me see. Chelsea says attorneys cannot ask a question if they know the answer will be a lie. Yes, that is also true. So their client will testify via narrative. I'm sure there are other reasons, but I never think highly of narrative testimony. That is also true, Cheryl C. That if they can't ask them the questions, the attorneys cannot promote perjury, things that they know are going to be a lie. Stargazer Kawaii says no helping being guilty of the crime. Nope, because they can get in trouble for that because we are officers of the court, even though we don't work for the court and they don't pay our bills. Sarah Boone's 13th attorney says us Florida people speak slower than the rest of the country. Yeah, I have to watch them on 2 times. I can't. Carly Reddy says, did you reach the like goal? We made our new like goal at 60. Yeah. Cheryl C says, I love being able to skip the sidebars and breaks. Yeah, I love that too. Because you'd be like, oh, I'm there for the 8 hours. But if I skip and I watch it on 2 times speed, maybe 2 to 3 hours, right? But anyways, y'all, like I said, new things coming to the channel. Y'all might see me posting a lot more than y'all are used to because I need to grow the channel. So sorry in advance if it's annoying. Sorry in advance if it's annoying, but I am trying to grow the channel and I hope that I will have all of y'all's support. I hope everyone has a wonderful weekend, and I will see y'all all on the next live stream. And also for the members, do be on the lookout in the membership tab so I can post for the next members live stream. I forgot to do it over this weekend, but I'm going to do it this weekend. Hold me to it. If I don't do it, I have to give away like a $10 gift card or something. So I will see y'all all on the next live stream. Bye-bye.